Thank you very much for this kind introduction. It's a pleasure for me to talk to you. I'm very sorry I could not come to Turkey this time. I've been there quite often. I hope you can see my slides. Is everything okay? Yeah. So let's start the new European Artificial Intelligence Act. Maybe it's coming soon because today, on this day, the trilogue discussions between the European Commission, the European Parliament, and the Council of Europe are supposed to reach their final stage. So today there may be a compromise, or in the next days. It's open. I had the chance to talk to some politicians yesterday, and they said that it's rather probable that a compromise will be reached. So the structure of today's presentation is as follows. First of all, I want to give you some information on the background, the European digital policy since 2010. After that, I'll talk a little bit about the AI Act as it is now, and then in the end, I will try to give you some information on how the AI Act can be evaluated. So let's start with an overview over the European digital policy. In a specific sense, it starts in 2010 when the first digital agenda for Europe was published. It was a communication from the Commission to the European Parliament. You see the specific title on the screen. And in this communication, the obstacles hindering a digital agenda for Europe were specified. The paper talks about fragmented digital markets, lack of interoperability, rising cybercrime, risk of low trust in networks, lack of investment in networks, insufficient research and innovation efforts in Europe, lack of digital literacy and skills among digital citizens, and missed opportunities in addressing societal challenges. Yeah? And in addition, the paper had some ideas about what must be done in order to achieve a European single market. There should be an enhancement of the interoperability of devices, applications, data repositories, services, and networks. The European Commission wanted to review the standard-setting procedures, promote appropriate rules for intellectual property rights. In addition, they aimed at consolidating online trust and security and wanted to combat cybercrime. Another task was to promote fast and ultra-fast internet access for all, to do investment in research and innovation, enhance digital literacy, skills and inclusion, and leveraging smart use of technology for society. So these were quite ambitious goals at that time, nearly 14 years ago. The Commission identified some key areas where Europe should invest most. This was climate change. I think that's interesting. Today, climate change is something that everybody is talking about, but even in 2010, climate change was identified as a very important topic by the European Commission. Then managing the aging population in Europe. This means a focus on e-health and telemedicine, the digitization of content, and intelligent transport systems. Intelligent transport systems means first of all, smart cars, autonomous cars. 5 years later, there was another communication on the digital single market strategy of Europe. And this communication said the strategy should rest on 3 pillars: better access for consumers to digital goods, the creation of digital networks, and the maximization of growth potential in the European market. What does this mean? Better access to consumers, to digital goods and services across Europe means we need rules to make cross-border e-commerce easier. So at that time, 10 years ago, everybody talked about e-commerce and the promotion of e-commerce. Then in addition, there should be a review of the regulation on consumer protection cooperation to enforce consumer rules more quickly and consistently. So a focus on consumer rules. More efficient and affordable cross-border parcel delivery. The Commission wanted to end unjustified geo-blocking, thus increasing choice and access for European online consumers. This has been done now. The Commission wanted, in addition, to identify potential competition concerns affecting European e-commerce markets. They aimed at a modern, more European copyright law, and they called for a review of the satellite and cable directive to assess whether its scope should be broadened to include broadcasters' online transmissions. And in addition, there was talk about the reduction of the administrative burden to businesses caused by different value-added tax regimes. So this is about a single market in Europe, also and especially for digital goods. The aim was to maximize the growth potential for the digital economy. The Commission talked about a free flow of data to promote the free movement of data in the EU. There was a mention of a European digital crowd. Priorities for standards and interoperability of devices were defined, and this also was relevant for specific application, data repositories, services, networks, and so on. And a special focus was put on the support of an inclusive digital society where citizens have the right skills to seize the opportunities of the internet and boost their chances of getting a job. So everybody should be skilled, not only a few people, not only an elite. So we talked about 2010, we talked about 2050, now 2020, the second digital agenda for Europe started. And it started with the communication the year 2021. And in this digital compass, I won't go into detail, there's talk about that at least 80% of all adults should have basic digital skills, and there should be at least 20 million ICT professionals employed across Europe. And as for business, 75% of businesses should use cloud computing services, big data, and artificial intelligence. So this is quite ambitious, quite an ambitious program that was set up in 2020. The infrastructure was also mentioned. All households in the EU should have gigabit internet connectivity, and 5G technology should be available in all populated areas. As for public services, all essential public services should be available online, and all EU citizens should have access to their electronic health records, and 80% should use an eID solution. So again, quite ambitious tasks and aims. So there have been, on this basis, a lot of quite important initiatives, and we don't have the time to go into detail. This is maybe an overview of the most important European digital initiatives since 2015. I just want to mention the most important ones. GDPR, General Data Protection Regulation, in force since 2018. The Digital Markets Act, the Digital Governance Act, the Digital Services Act, the Data Act, the EHDS, European Health Data Space, the e-privacy regulation, and the Artificial Intelligence Act. So in order to understand the European digital policy, you cannot just focus on the AI Act. You have to take account this variety of acts and activities. So let's talk a little bit about this background, because it's important for an understanding of the Artificial Intelligence Act. First of all, and most famous, is the General Data Protection Regulation, the GDPR. It's about the protection of privacy in Europe and beyond. The basic structure of regulation is that private data may not be collected, stored, or processed unless a law permits it or the data subject consents. That's a logical structure of data protection in Europe. Private data are protected, and it's only allowed to use them if there is a law or the data subject consents. This perspective relates to data processing by the state, but also by private parties. So the GDPR is directed towards the state, but also towards private parties. There is no data ownership regulated in the data protection regulation. That's very important. Maybe later in the discussion we have time to talk about that in more detail. The GDPR was criticized because of too much bureaucracy. I'm not quite sure whether this is a fair criticism. Today, one can say that the GDPR has become the international gold standard of data protection. The GDPR is discussed not only in Europe, but also in Eastern Asia, in China, in Japan, in South Korea, in Latin America, in many countries. Yeah, it's an international gold standard of data protection. And there has been something like, that's called the Brussels effect. This means the data protection regulation basically is only relevant for Europe, but it affects also standards in other countries. So Brussels has somehow managed to regulate data protection worldwide. Then very short, the Digital Markets Act, DMA, it's about securing more competition on the European digital markets. The goal is the prevention of quasi-monopolies. It's aimed at big American companies. And the new concept was introduced, the concept of a gatekeeper, a platform company with highly market power. And these gatekeepers are really heavily regulated. Digital Markets Act. And the Digital Services Act. This is a little bit, it's close to criminal law. The Digital Markets Act regulates obligations of large internet service providers, for example, due diligence, accountability obligations, and so on. Providers of online platforms and social media are particularly affected. Similarities to the German Network Enforcement Act are easy to see. Basically, the Digital Services Act is a Europeanization of the German Network Enforcement Act of 2017. And the specific focus is on the idea that platforms must give users opportunities to appeal and cooperate better with government authorities. Because before this regulation, before the Digital Services Act, companies like Facebook or Google hardly reacted to European criticism or European asks or requests for taking offline specific content. So the Digital Services Act forces them to do so. Then there is the Digital Governance Act, the DGA. This shall facilitate the availability and sharing of data. Data are considered the oil of the 21st century, and the sharing and availability should be between individuals, business, and government. Particularly important in this act is the area of agriculture, the area of health, the area of mobility, and the area of environment. The aim is to use data for the common good. And specific aspects that are mentioned are efficiency, value creation, innovation in business and research. And some new aspects or some new concepts are also introduced, the concept of a data trustee and the possibility of data donation. Maybe later in the discussion, we can go more into detail. The Data Act is also very important, quite new. The Data Act shall facilitate access to and trade with data. It's aiming at breaking out data silos. Again, there is no data ownership. In Europe, we have no data ownership, but we want to facilitate the trade with data. And in this Data Act, there are specific, quite complicated rules on the disclosure and use of data. The European health data space must also be mentioned. Its aim is to enable cross-national exchange of health data. Cross-national exchange of health data. One aspect is, or one important task is to define a specific electronic format for health data in order to ensure interoperability. And the EHDS asks for opportunities for secondary use of health data by government and private research. So there should be more trade and more work done with health data. E-privacy regulation is also important. It's about the protection of fundamental rights and freedoms. In this respect, very similar to the GDPR, and values that are considered particularly important are privacy, confidentiality of communications, the protection of personal data in the field of electronic communications, and the free circulation of electronic communication data. So what can you say about this? What can we say? So the overall rating, I would say what we see here is the development of classic data protection law, GDPR, into a new data economy law. So Datenschutzrecht is developing into Datenwirtschaftsrecht. That's what's happening in Europe. The goal is to make data usable for health, business, and research, ultimately for the common good. So it's no longer only about protecting data. Today, it's also important to consider data uses in order to promote health, business, and research, ultimately the common good. And in the future, there will be, I believe, 3 pillars of European data law: the data protection law, the traditional law, data economy law that is now emerging, and data criminal law, which is also already existing. It's very important, but it's not my topic now. Yeah. There are specific problems with regard to the massive number of these acts, because it's difficult to delimitate the borders and harmonize the new legal acts among each other and in relation to the GDPR. So there's an overlapping regulation, which is a big problem. It's a big task for European lawyers today to harmonize all these acts. So, yes. So now I will come to the next part of my presentation, the European AI Act. Are there any questions so far? Can you understand me? Is everything okay? Not too fast? Yeah? Okay, good. Then let's talk about the European AI Act, and this time we will go into more detail. I just gave you an overview of the historical background, gave you an impression of this variety of new European digital acts, and now we talk about the European AI Act in more detail. So what is the European approach? The aim is to foster excellence in AI in order to strengthen Europe's potential to compete globally. Yeah? So this regulation is from the beginning aiming also at economic aspects. Yeah? They want to compete globally. The EU wants to achieve this by enabling the development and uptake of AI in the EU, making the EU a place where AI thrives. They talk about from the lab to the market. They want to ensure that AI works for people, not for government, not for big business, and they want to build strategic leadership in high impact sectors. Maybe I should comment on this proverb, not for government, not for big business. That was something we often made jokes in this European high-level group. We said that in the US, AI regulation has the aim to please big business. In China, AI regulation aims at supporting government. But in Europe, AI regulation should work for people, should work for citizens. Of course, this is very general. It's not correct in the strict sense, but I think all in all, it's not quite wrong. So some background remarks of the Commission on artificial intelligence. They say, that's a quotation, that artificial intelligence is a fast evolving family of technologies that can bring a wide array of economic and societal benefits across the entire spectrum of industries and social activities. By improving prediction, optimizing operations and resource allocation, and personalizing service delivery, the use of artificial intelligence can support socially and environmentally beneficial outcomes and provide key competitive advantages to companies and the European economy. So the basic idea of artificial intelligence is that artificial intelligence can improve prediction. It can be used for prognosis. It can optimize operations and resource allocation, and it can personalize service delivery. The quotation goes on. Such action is especially needed in high impact sectors, including climate change. Again, yeah, you remember the Agenda 2010. Yeah, here again, climate change, environment and health, the public sector, finance, mobility, home affairs, and agriculture. However, the same elements and techniques that power the socio-economic benefits of AI can also bring about new risks or negative consequences for individuals or the society. And that's the reason why we need regulation. There are a lot of advantages, a lot of chances, but we also must see the problems, and therefore we need regulation. And that's a quotation of the proposal of the AI Act that was published in April 2021, now 2 years ago. Why do we need rules on AI? The Commission's ideas are as follows. Europeans should have trust what AI has to offer. Therefore, there must be rules. Certain AI systems create risks that need to be addressed to avoid undesirable outcomes. For example, it is often not possible to find out why an AI system has made a decision or prediction and reached a certain income. And therefore, it may become difficult to assess whether someone has been unfairly disadvantaged, has been discriminated against, such as in a hiring decision or in an application for a public benefit scheme. Now, the decisions of AI are not easy to understand, and therefore we need rules to make sure that they do not discriminate against specific groups. Although existing legislation provides some protection, for example, the GDPR, it is insufficient to address the specific challenges of AI systems that are coming today. So what we need is a more general approach. That's the basic idea of the European Commission, and that's the background of this initiative in the year 2021. Specific objects of the AI regulation proposal are to ensure that AI systems placed on the union market and used are safe and respect existing law and fundamental rights and union values. Yeah, the systems must be safe and they must respect existing law, existing European law. The systems must ensure legal certainty, Rechtssicherheit, to facilitate investment and innovation in AI. The proposal aims at enhancing governance and effective enforcement of existing law on fundamental rights and safety requirements applicable to AI systems, and it aims to facilitate the development of a single market for lawful, safe, and trustworthy AI applications and prevent market fragmentation. So again, the idea of a single market. That's always very important in Europe, a single market, not only the German market, the French market, the Italian market, the Spanish market, but a single European market. The single European market is the largest market in the world. National markets are not so important. In the background of this new regulation, there's the work of the high-level expert group on AI. Now, I had the honor to participate in that group as one of the German members. There were all in all 52 experts from all over Europe, from France, from England, from Spain, from Italy, from Switzerland, from Italy. So every country sent some experts. I was, by the way, the only law professor from a German-speaking countries. The other Germans were people from NGOs or from parliament or from specific companies, but I was the only university person from law, and then there was a colleague from philosophy. We met in Brussels from 2018 to 2020, and we worked very hard. In 2019, in April, we were able to publish a first set of rules, the ethic guidelines for trustworthy AI. You'll find these online. It's an interesting paper. It's not very long, maybe 30 pages. It's easy to read. We tried to make it as understandable as possible, and this was published in 2019. There were three other papers, another one at the end of 2019 2019 and then 2 papers in 2020. Unfortunately, in 2020, Corona came. So we could no longer meet in person. We had discussions online, and these discussions online were not so very good. Sitting together was always gave us a chance to reach some compromise, and we talked deep in the night sometimes. But these online discussions tended to be a bit superficial, and I did not like these discussions very much. And this also, to my mind, shows in the papers. I believe this first paper, the Ethic Guidelines for Trustworthy AI, are by far the most important paper that we produced. In addition, there was an AI Alliance, a platform for approximately 4,000 stakeholders from all over Europe to debate the technological and societal implications of AI, culminating in the yearly AI Assembly. These stakeholders were mostly, for the most part, people from big companies, but also NGOs and national groups. So very active and quite well prepared. People who participated in the discussion, and we tried to take up their ideas, to discuss also their ideas. And from this came the EU white paper on AI that was published in February 2020. This was, so to speak, the main result of the work of the high-level group and this AI Alliance. So it started with the high-level group, then came a discussion, Europe-wide discussion inside this AI Alliance, and the result of this was an EU white paper. The white paper does not contain law. It's still analysis and morals and ethics and economic analysis, not yet law. The law came into existence in form of a draft proposal in April 2021. So the result of the discussion of the white paper was the proposal of an AI Act. The AI Act was proposed by the Commission, which is normal in the EU, and it addresses risks specifically created by AI applications. It concerns only AI. It proposes a list of high-risk applications. We'll go into some detail in a moment. The draft sets clear requirements for AI systems for high-risk applications. It defines specific obligations for AI users and providers of high-risk applications. It proposes a conformity assessment before the AI system is put into service or placed on the market. It proposes specific enforcement aspects after such an AI system is placed on the market. And in addition, there is the plan of a governance structure at the European and national levels, both at the European level and at the national level. It's a long draft. We can't look at all the details. As far as I have heard, the decision that may be reached today will be very similar to this original proposal. So it seems that the criticism that has been brought against this proposed AI Act has not been accepted by the Commission and will not be found in the AI Act. But it's not yet quite sure. We have to wait until tomorrow. Tomorrow we'll know whether the AI Act will come into force or not. So the basic structure is that the AI Act follows a risk-based approach. So the AI Act says there are 4 groups of AI systems. The first group is so dangerous that it poses unacceptable risk, and it's forbidden once and for all. The second group consists of AI systems that pose high risk. They are allowed, but they are heavily regulated. And then there are 2 other groups, the group of low risk and of minimal risk. The low risk and minimal risk groups, they just have to be transparent and make clear that it's AI you're talking to, but nothing more. So the most important aspects are definition of unacceptable risks, what will be forbidden in the European Union, and the group of high-risk AI systems. These systems will be heavily regulated. So what are unacceptable risk AI systems. Yeah, these systems will be not allowed in the EU. These systems are all systems considered a clear threat to the safety, livelihoods, and rights of people. First group is the group of all techniques or all technologies that exploit vulnerabilities of specific vulnerable groups, such as children or persons with disabilities. So AI systems that aim at exploiting the weakness of specific vulnerable groups will be banned in total. The second group of AI systems that is considered unacceptable are AI-based social scoring systems for general purposes done by public authorities. So general scoring of European citizens will not be allowed. In specific areas, social scoring can be acceptable. In Germany, we have systems like Schufa that are considered problematic, but are accepted in society. But the states in Europe, the nation states in Europe, will not be allowed to monitor and produce scores of their citizens for general purposes. And something that is quite interesting from a criminal law perspective is that also real-time remote biometric identification systems in publicly accessible spaces for the purpose of law enforcement will be prohibited unless there are specific limited exceptions given. We need a court decision to use a public camera, for example. So this is also something quite important. These groups of AI activities are considered unacceptable, and therefore they will be probably forbidden in total. Then there's a group of high-risk AI systems. High-risk AI systems will be under close control. They are allowed, they are can be put into practice, but there will be much control of these systems. What are these systems? First of all, systems concerning critical infrastructures, for example, transport, that could put the life and health of citizens at risk. So AI systems controlling road transport fall under this category. Then are mentioned systems of educational or vocational training that may determine the access to education and professional course of someone's life. For example, the scoring of exams with the help of AI. That's allowed, but it will be heavily regulated. The third group is a group governing safety components of products. For example, AI application in robot-assisted surgery. Then important is also the group of employment, AI in employment, AI in workers management, AI that opens up access to self-employment. For example, CV sorting software. So the software that is AI powered and sorts CVs for recruitment procedures. Other examples of high-risk systems are AI systems that fulfill essential private or public services. For example, credit scoring systems. The credit scoring system is not a general system, it's a specific system. It concentrates on credit. This will be allowed, but only under specific regulation. High-risk systems are also systems of law enforcement that may interfere with people's fundamental rights. For example, in criminal law, the evaluation of the reliability of evidence. For example, a specific, very important example is a truth detection system. We have today truth detection systems that rest on AI. They are very good. You can, in many cases, realize whether someone is lying or not. These systems will be allowed. This will be not forbidden, but there will be a heavy regulation on it. Then another system is, another group of systems that are considered high risk are systems in the areas of migration, asylum and border control management. For example, the systems used for the verification of authenticity of travel documents. As you all know, Europe has a big problem with migrants coming over the Mediterranean Sea, for example, and on the borders in Italy, but also in Austria, also in Germany, there are AI systems used for the verification of the authenticity of their travel documents. And this is okay. The AI Act says that's okay, but there's heavy regulation on that. And another area that is considered high risk is the area of administration of justice and democratic processes. For example, systems that apply the law to concrete set of facts. More concrete, an AI judge. AI judges may be legal, but only under specific circumstances. So that's quite a list, and all these points are interesting. We don't have the time to go into more detail. I just want to give you a very short information, a very short overview over the remaining groups of limited risk and minimal risk. Limited risk means AI systems with specific transparency obligations. So when a system falls under the category of limited risks, all that has to be done is to make these systems transparent. When using AI systems such as chatbots, users should be aware that they are interacting with a machine so they can take an informed decision to continue or step back. So if you phone, let's say, a governmental office and someone is talking to you, you must know whether you are talking to a human being or whether you are talking to a machine. The machine must make this transparent. And minimal risk, this means that you are free to use it. The proposal allows a free use of applications such as AI-enabled video games or spam filters. And the vast majority of AI systems currently used in the EU falls into this category, and they represent minimal or no risk. A big challenge, and that was one of the main points why there was so much discussion since spring 2021, is that it was unclear under which category ChatGPT and other systems like ChatGPT could fall. ChatGPT is not a specific system, but can be used for a variety of purposes. So it does not fit in well into these categories of forbidden risk, high risk, limited risk, minimal risk. So I gave you now some information on the risk categorization. And now let's have a brief look at the regulation of high risk systems. As I said, systems of unacceptable risk, they are simply forbidden. It's not allowed to put them on the market. The systems of low risk and minimal risk are allowed with specific regulation. That's no problem. But what is interesting is the regulation of high risk system. This regulation is quite complicated, maybe too complicated. High risk systems will be subject to strict obligations before they can be put on the market. There must be adequate risk assessment and mitigation systems. There must be high quality of the data sets feeding the system to minimize risks and discriminatory outcomes. We say, as for AI systems, garbage in, garbage out. If you use bad data, then the system will not work well. What is necessary in the area of high-risk system is the logging of activity to ensure traceability of results. People should be able to understand the results of an AI system. There must be a detailed documentation providing all information necessary on the system and its purpose for authorities to assess its compliance. That's a burden that is also put on the producer of the system. There must be clear and adequate information to the user. Citizens must know the details of the system they are using. There must be always appropriate human oversight measures to minimize risk. Humans must remain in control, and there should be an overall high level of robustness, security, and accuracy of these systems. So I put these ideas on one slide. In the paper, the regulation, it's 20 or more pages. It's extremely complicated. To my mind, too complicated. And here, I'm coming now slowly to the end. You see the procedural perspective. Step one is where a high-risk AI system is developed. Then the system in Europe will need to undergo the conformity assessment and comply with AI requirements. It will be decided whether it's an unacceptable risk system, high-risk system, low-risk system, minimal risk system. The next step, registration of standalone AI systems in an EU database. All AI systems in Europe will be registered, and it will be clear in which category they fall. Then, step 4, there will be a declaration of conformity needs to be signed, and the AI system should bear the CE marking. And only then can the system be placed on the market. So it's a specific procedure to be followed before you are allowed to place the system on the market. And if substantial changes happen to the AI system's life cycle, for example, if new software is introduced, then the system has to go back to step 2, and there will be a new conformity assessment. That's a basic idea. And this means the state, Europe, and the national states, they want to have control over the AI systems that are placed on the European market, because AI systems are considered to be dangerous. That's my short overview of the background of the AI regulation and the most important content of the regulation. Now some critical perspectives, now some ideas how to criticize this regulation. Some people say the AI Act is not restrictive enough with respect to biometric controls in the public. So the use of cameras in the public, in principle, it's forbidden, but it can be allowed by courts when it comes to criminal law. And some journalists, for example, some politicians argued, no, it should be banned in total. There should be no public analysis, no public cameras at all. I don't think that's a good idea. I think for the purposes of criminal law, we need some biometric controls in the public. It should not be everywhere, like in some other countries, but it should be in specific areas. Another criticism was that the Artificial Intelligence Act is not binding when it comes to military use of AI. That's true. The AI Act is not relevant for the military. It's not a regulation that's relevant for the military. It's a regulation that's relevant for the economic market. It's unclear whether national security issues can legitimize AI control. So some people fear that national security issues may legitimize AI control. I have to admit, I don't really understand this argument. There's a pretty clear definition of high-risk systems, and they are governed by specific regulation, and there is no possibility to introduce out of hand new AI systems that do not fall under the control of the AI regulation. So national security issues cannot legitimize additional AI control. Some people criticize use of AI to secure EU borders. But at the moment, the situation in Europe is so problematic, and we have so much problems with the migrants coming in, that this criticism also is not very convincing at the moment. Some people argued that in the AI Act, you find not enough protection options or legal action options for citizens. Rechtsschutzmöglichkeiten for citizens against this regulation. This may be true, but I believe this problem should be solved and can be solved on the national level within the nation states of Europe. Some argue that the definition of the AI Act of artificial intelligence is not precise enough. It's too broad, that may be the case. Yeah, that's something probably in the new version, in the latest version that's talked about today and tomorrow, this definition will be improved. Yeah? And of course, there's a big question of ChatGPT. Will ChatGPT be considered high risk? This could mean that ChatGPT cannot be used in Europe at all, or will there be another regulation for ChatGPT, or maybe will there be no regulation at all for ChatGPT? That's open. Some governments said that self-regulation for ChatGPT would be enough. Others said that ChatGPT is a high-risk system. Probably the result will be somewhere in between. So all in all, I would say that the AI Act is a powerful attempt to regulate AI, one of the first attempts worldwide. It centers on a risk-based approach, which is something new in Europe. There is a need for clarification what exactly is the borderline between low-risk and high-risk systems. That may be a problem. And of course, we have to make clear who's allowed to define the difference. And there will be new discussions also in the future and modifications of the AI Act because of ChatGPT and other systems. And here again, let's look into the future. So what we were talking about now was a Commission's proposal in April 2021. Then there was a lot of public discussion in 2022, 2023, several new draft versions. All of them have been heavily criticized, and from what I've heard, the first proposal, the Commission's proposal from 2021, has the best chances to become law. Today, on the 6th December of 2023, the last trilogue discussions will begin. This means discussions between the EU Commission, the EU Parliament, and the Council of Europe. Then the Parliament probably will decide at the end of this year or at the beginning of next year. And this would mean the regulation could enter into force in the first half of next year for a transitional period. If it is not, there's no decision that it will enter into force now, this would mean that it will take a long time to start the discussions, because in next year, 2024, there are the elections for the EU Parliament, which create a lot of disturbance. And this would mean that new discussions would start probably only in 2025. So it's either today or it will be in 2025 or not at all. So if the regulation enters into force in 2024, it will enter into force first of all in the transitional period. And in this period, standards would be mandated and developed, and the government structures set up would be operational. Now one must have standard structures, governance structures, how to deal on a national level with these new regulation. And in the second half of 2025, that's the earliest time the regulation could become applicable to operators all over Europe. And with this, I come to an end. I talked for 1 hour. I think that's enough with such a problematic topic. Thank you all for your attention. And now I'm looking forward to your questions. Thank you.
Thank you, Professor, for this outstanding presentation. Now we can proceed to questions. There are some participants who are raising hands. So, Mr. Kızılırmak, will you please help us about this issue for receiving the questions, please?
Of course, thank you, Professor. And I would like to especially thank Professor Hilgendorf for this outstanding, comprehensive speech for his conference. I believe that we have been enlightened on the matter. First, I saw the hand of Professor Yeni. So if you would allow me, I would like to give the floor to him. Yes, Professor Yeni, you may.
Well, thank you for giving the floor. And thank you, Professor Hilgendorf. Very nice to see you.
Yeah, the same. Thank you. Good to see you too. Hello.
Hello. So it was very interesting, your talk, and thank you for that talk. And I have two questions. One question is about the risk assessment. So you mentioned that there will be risk assessment, but who is going to make the risk assessment? Is it artificial intelligence again? Or how can you assess risks of this application after they come in front? And my second question is about how can we use artificial intelligence for legal education? So is it a good idea to use artificial intelligence in legal education? I heard in United States there are some examples started, and they tried to make one simulation of a courtroom, for example, by artificial intelligence, and students go in and make training there. So what is your opinion about legal education and artificial intelligence?
Okay, thank you for these questions. I will start with the first question. Who is going to do the risk assessment? So the risk assessment will be done by the companies that want to introduce their AI systems on the market, and they have to do an efficient risk assessment and detailed risk assessment, and they have to document their risk assessment, and then this will be reviewed and controlled by a specific state authorities that are to be set up on the national level. Yeah. In Germany, for example, it's not yet quite clear which institutions will be in charge of controlling these risk assessments. Probably, or maybe, it will be those authorities that at the moment are in charge of data protection. Now we have institutions for data protections in Germany, quite a lot, and they could also be in charge of this AI risk assessment. Second question, AI in legal education. So when it's not about sorting out CVs or assessing the quality of students, I would say AI systems in legal education will fall under the category of low risk or minimal risk. So in principle, they are allowed. So the question is, are there good systems at the moment? I would say maybe there's a chance for the future to have AI in legal education. But one has to be careful about it. I would say it will never be possible to get rid of humans at all. Teachers will be necessary, yeah? So without teachers, there can be no education. But maybe there could be AI systems in addition to human teachers, for example, for language control, for example, for the structuralization of cases, for solution of cases, for, let's say, for tasks that are a bit boring for teachers, always the same, and the students could talk to an AI system. And I believe most of you will have experience with ChatGPT, for example. And ChatGPT is amazingly good at answering questions, and I think it could be used in legal education as well. And to give you one example, in Würzburg, we are now planning to build a chatbot with specific cultural traits for students who should train how to deal, let's say, with witnesses with a Turkish background. The German law students normally we have a big problem when it comes to practice. We have not enough practice, and we haven't any practice with people with a different cultural background. So our students could become a judge or a public prosecutor and never had the chance to train how to deal with a witness from a foreign culture. And this situation could be improved by programming a chatbot with specific language problems, German language, with a specific cultural background, and the students could learn how to talk to such a person, to such an individual. Because we see that at the moment, many witnesses, they are not the people that are accused, they're just witnesses. But these witnesses have problems with the German court system because they don't know the details. Both the witnesses are nervous and the judges are nervous, and this situation could be improved by educating both sides with the help of AI systems. Just an example of a very advanced system. So my short answer to your second question would be yes. I think that we could use AI systems, but in addition, I would say AI systems will never be as good as you. So the humans must remain in the loop. We will always have to have human teachers on top.
Thank you.
And now Professor Eras'dan raises his hand.
Okay, thank you. Thank you very much, dear Professor, for this very informative talk, and also for accepting to give this presentation to us. I would like to ask two questions. One is pertain to a clarification concerning one issue that you mentioned during your presentation. That is, actually, you said that while talking about this high risk issues concerning AI use, you mentioned that law enforcement agencies may use AI to detect lies, for lie detection. And I'm wondering whether you meant by that the neurotechnologies, especially brain imaging technologies that are used in this aim, or whether there are other AI technologies that can be used in lie detection, except on this brain-machine interfaces that can detect brain activity during testimony. And so this is my first question. And the second one, I'm afraid maybe a little bit out of the scope of your presentation, so you are free not to answer it. I'm not going to take it personal if you don't answer it. But you mentioned that national security issues cannot be used in legitimizing AI control. So national security cannot be a pretext for using AI in controlling social activities. I understood that in this way. My question is whether there is a need to control AI which is used in national security issues. I mean directly the war industry, the use of AI in the war industry, making weapons that are directed or directly using AI technologies. As I said, this may be out of the scope of your presentation. It is clearly out of the scope of your presentation, so you are free to answer it or not. Okay. I won't be insisting. So thank you very much again.
Thank you. Thank you. I will start with the first question, the lie detection systems. So there has been discussion on lie detection systems already in the 40s and 50s. So a long time since, a long time ago. And the newest technology or new technology is exactly what you mentioned, brain analysis and pictures of the brain and so on. But AI is even more powerful. AI can use cameras. It can control your pulse. It can control your blood pressure. And with the help of these data, AI seems to be able to decide very effectively whether someone is lying or not. So we don't need pictures. Pictures are additional help for AI, but just by looking at your face, that's said, yeah, just by looking and analyzing your mimics, yeah, your facial expression, AI seems to be able to detect lies. And this is what experienced judges also can do. An experienced judge will say, somehow I feel it, whether he's lying or not. This feeling can be translated into objective facts and can be analyzed. And it seems that these machines can do that. So there are studies that show that the ability of AI systems to detect lies just by analyzing the visual expression is very high. There can be no absolute guarantee that the one is lying, but they are very good at detecting people that probably are lying. And the second question, well, what I wanted to say is that some people are afraid that aspects of national security do not fall under the AI Act. And my answer to this criticism was, as long as it's not a military use, but use of state authority with the aim of improving national security, this falls under the AI Act, and there is no exception for this area. If national security aspects are, for example, brought into criminal law, then they will fall under high-risk systems, and they are regulated. Military use is something different. The answers to national security can be police work and can be military work. Military work, military aspects, that's true. They are not regulated by the AI Act. That's I think also a European tradition in most countries of the world, I think. The military is outside normal control. This has advantages, but also disadvantages. I believe the AI Act would never have become, or would never have a chance to become law if it would govern the military use as well. The French, the Germans, Italy would not accept a regulation of their military systems by a European lawgiver. And therefore, the military is taken out, but national security does not necessarily mean military. National security can also mean police. And police work is regulated by the AI Act.
And now, Ms. Selin Çetin from Istanbul Bar Association. Yeah.
Hello. Thank you so much, Professor, this great presentation. I have 3 questions. As you mentioned, the EU holds the last trilogue meeting today, and the hot topic is self-regulation of foundation models. And as you know, the countries Germany, Italy, and France support this. And what's your approach in this debate and your prediction on the final version of the AI Act on this issue? My first question. I can follow other questions after your answer, or I can ask all of them.
You can, if it's only one, you can ask the other one. If there are many more, you should ask them step by step.
Okay. The second one is there are many different sector-specific regulations, such as health, transportation, etc. But when it comes to AI systems, and while they have foreseen various requirements, obligations, and the AI Act also have many obligations for high-risk AI systems. Do you think it could cause over-regulation of some sectors in practice? And the last question is about standards. AI Act mentions standard issues, and there are many different technical standards when it comes to AI systems. And do you think how they will affect the adaptation and application of AI Act in the following years? Thank you so much. Okay. I'm very happy to see you, even if in online environment.
Yes, these are interesting questions. Maybe the last question should be more elaborated on a little bit. I'll start with the first question. Maybe I should give some background information for the other listeners. Yeah? So, as I said, or as I tried to make clear, the original draft of the AI regulation did not talk about foundational models or models like ChatGPT. It is a general AI that is not used for specific purpose, but AI that can do everything. This was not regulated at the beginning. And then in November 2022, ChatGPT was published and was a big success also in Europe. And it was not clear under what category this would fall in the proposed AI Act. And some people said this is high risk system. Others people said it does not fall under any category. We have to regulate it, to find a new regulation. And one of the positions in this discussion was a position taken by the German government and the French government, and they said, we must not over-regulate systems like ChatGPT because otherwise startups in Europe will be under too much pressure. And let's just ask them to self-regulate. So the idea was to have an obligation to self-regulate. And this is now part of this trilogue discussion. You asked me whether I believe that this has a chance to become law. I would say probably no. I believe that systems like ChatGPT will be regulated, maybe not as heavily as high-risk systems, but there will be more regulation than simply self-regulation, because self-regulation in principle means nothing. Yeah? There's no regulation at all. And one should also consider there are some advantages for regulation also for companies, because if a technology is regulated, for example, if certain safety standards are prescribed, then a company that complies with these safety standards can be said to be acting orderly. They are not acting negligent. If there's no regulation, there could be a lot of discussion what negligence means with the perspective on AI. If you have a regulation that gives detailed information what these companies have to do, then these companies know what is considered negligent and not, and this is gives them some legal certainty, and it helps them. So many companies ask for regulation, but of course not too much regulation and not too much bureaucracy. And that's your second question. Is there a danger of over-regulation? I would say yes. I believe the second part of the draft is too complicated. The notifying authorities and bureaucracy, and it's very difficult even for me to understand that. And I was member of this high-level group, and we always said there should not be too much bureaucracy. Things must be clear and easy to understand. But now the draft, at least to my mind, is too complicated. That's it. Especially when it comes to procedural questions. Yeah? And I hope that the trilogue discussion, this problem will be solved. Yeah? And now I have to admit, I did not absolutely understand the third part of your question. Maybe you could repeat that?
Third one, it was about standards. I couldn't remember which articles, but the AI Act mentions adaptation of standards. If you adapt some standards, you don't need to provide some requirements or obligations. I mean, there are many technical standards when it comes to AI systems. So how they will affect the adaptation of and application of AI Act in the following years?
Well, there must be some standards in order to make sure that there will be a single market. Now, the interoperability of systems requires specific standards. But when you fix specific standards, there's always the danger that these standards can be old-fashioned very soon because technology is evolving so fast. So the EU lawgiver has a task to define specific standards, but at the same time has to make clear and open up the possibility that these standards can be changed with evolving technology. And that's also not an easy task.
Mhm.
So I wouldn't say that the definition of standards is a bad idea. There must be standards. If we have too many divergent systems, there's no way to communicate between, let's say, French, Italy, and French systems, Italian systems, and German systems. There must be a standardization of AI systems, data formats, and so on. But these things change pretty quickly, and the AI Act must be open for quick change too. And that's not an easy task.
Yes, thank you so much.
Now I see so many questions. If Merve D raised her hand first, so I will give her the floor, but with a brief warning. If you may keep the question brief, we would appreciate it. Merve D, you can unmute yourself.
Thank you, Mr. Kızılırmak. Firstly, apologize for my camera. I am in a public space. I couldn't open it. I am Merve Duysak. I am working as an assistant professor at Okan University. My area of expertise is criminal law. Thank you for your presentation, Professor. I will ask something about unacceptable risk. Actually, you mentioned a little bit your opinion, but I would like to ask directly some problems. Unacceptable risk groups, there is remote, real-time remote identification systems. You mentioned that, yes, it's forbidden, but with judicial authorities acts, it could be used, and it's okay, it could be used with the judicial authority if they granted authorization. But in Turkey, I would like to mention that too, maybe. For public authorities actions, there are some problems, especially regarding the data. In Turkey, the data collecting from public authorities is not protected with the Data Act. There are some issues like that. And in the real-time remote biometric identification systems regulation in AI Data Act, there are some exceptions. I would like to shortly ask, but sorry for this. I summarize that. What is your opinion about real-time remote biometric identification system regulations with exceptions? Is it sufficient with judicial authority? What's your opinion again? Thank you for your presentation again. Thank you for your opportunity, Mr. Kızılırmak and Kadir Has University.
Yes. Well, I believe we should see in your question two different questions. Yeah, the first aspect is whether to use remote control in public areas like cameras with facial detection, cameras that can analyze the way you are walking, cameras that take photos of you, and so on and so on. Yeah, there are a lot of possibilities. Technology seems to be able to identify humans simply by the way they are walking. They don't need a facial analysis. Simply the way people walk identifies them. This is a problem because the state authorities, in principle, could know wherever individual citizens move. Wherever citizens are, this can be detected by cameras, and the data can be collected and brought together. So that's a danger of total control of citizens. And this is considered a bad idea in Europe, and we don't want it. And we say this specific analysis is only possible in public areas, not in private areas, not in universities, for example, only in public areas like train stations, big places, and so on. And only this data can only be used when the court decides that it's okay to use them. That's a first question. I think that that approach is acceptable. And the other aspect is data collection and dangers for privacy. If these dangers are not deleted after use, but are collected, this would be very problematic because this would help public institutions to exactly know what you have done yesterday and the day before and the day before and before and so on. Yeah, so there can be profiles of your everyday life, and this is not compliant with the idea of privacy, and therefore this should not be done. So I would say that control of public spaces with the deletion of data after their use, that's okay if a court decision supports it, but collection of data of all the citizens without time limits, this is not acceptable. But this would fall under the GDPR, not under the AI. So GDPR is relevant, and the GDPR does not allow that at the moment. That's a question. So I think one should clearly realize that the answer to specific questions very often cannot just be taken by looking at the AI Act. AI Act is only part of the picture. You have also taken into account the GDPR and other regulations I mentioned, which makes the analysis quite complicated. I admit that.
Thank you so much.
Now I see two last questions, and it is also getting late. Professor Hilgendorf is getting exhausted. Maybe we can take these two last questions. Mr. Karatay, I see that you raised your hand first, but would you like to pose a question?
Yes, Mr. Kızılırmak, thank you very much. Professor Hilgendorf, thank you for the valuable presentation, and thank you for Kadir Has University. One question, what's your approach to ongoing process of AI regulation in the Europe in terms of satisfying to Convention of Human Rights protections, in terms of AI using of administrations, public administration, using for the preventive measures?
Well, the AI Act is the European attempt to strike a balance between the needs of public control and basic rights and human dignity. And we will say that AI is a powerful tool, very powerful tool, and a potentially extremely dangerous tool. Therefore, there must be a regulation, and the AI is this regulation. So in the background of the AI Act is the idea that basic rights and human dignity must be protected. This is not exactly mentioned because we have the EU Charter and other regulation that, of course, are relevant, and the AI Act, so to speak, makes clear what is considered acceptable in Europe and what is not considered acceptable with regard to basic rights.
Thank you. Thank you.
Thank you. And I saw the hand of Miss Aybüke Tunç. Would you like to pose a question as well?
Actually, Selin, she wants to ask the real last question, so I wonder much more her question. So I gave my position to Selin. Okay, Ms. Çetin, you may ask your question.
Thank you so much again. My real last question about OECD's AI definitions. As you know, OECD updates the definition. but still there is debates about it. For example, it includes according to some ideas, it includes the anthropomorphic language and the possibility it could exclude deterministic rule-based AI systems. And what do you think about the definition of AI of the OECD? Because highly possible to it will affect both AI Act and the draft international convention of the Council of Europe. I just want to ask this question lastly.
So if I understood you right, the question concerns the definition of AI.
Yes, especially specifically OECD's definition.
So first of all, one should realize that in everyday use in Europe, AI is not well defined. So one definition is AI that are all systems that can solve tasks that in former times could only be solved by humans. That's an everyday understanding. Then another definition of AI is intelligent systems that are able to learn. So this aspect of learning is relevant. And the AI Act is somewhere in between. It talks about AI systems or intelligent systems that can solve tasks. Then it talks about how the systems were programmed and made with statistical methods and Bayesian methods and so on. And to my mind, this definition is very, very broad. So in the end, the definition of AI of the AI Act may be too broad and too much falls under its scope. And this means that, for example, regulation for autonomous cars or regulation for medical appliances, we have this in Europe quite a lot. Yeah? They are kind of overridden by the AI regulation. We have an overlapping regulation when it comes to automobiles and AI systems, because the understanding of AI, according to the AI Act, is so broad that specific systems inside cars are also covered. And therefore, cars will fall, modern cars, autonomous cars, will fall both under the traditional regulation and under the AI Act, which is a problem. And therefore, I hope that in the trilogue discussions today and tomorrow, the definition of AI will somehow be, there will be more precision to that, because we don't need a regulation that is so broad.
Thank you so much.
Seeing that there's no other question, and with so many valuable questions and contributions, I would like to give the floor back to Professor Katoğlu. Buyurun hocam.
Thank you, Mr. Kızılırmak. Dear Professor Hilgendorf, I would like to express my gratitude once again. Your presence was a privilege for us. I thank you very much for this outstanding presentation. And also, I would like to thank to all distinguished participants, Professor Yenisey and other distinguished participants. And I wish you all a good evening. Thank you for participating.
Thank you. Thank you for this wonderful discussion. And I really want to come back to Turkey as soon as possible. I really miss your warm weather and the beautiful tea and the very good food. So I promise to come as soon as possible.
We are looking forward to having you.
Thank you. So goodbye.
Bye. Bye to everybody. Good evening.
Good evening.
And congratulations for this wonderful meeting.